Since 1983, FAME has helped business and education work for Maine. Contact the authority, the Finance Authority of Maine. You're watching Mainebiz Sunday, Maine's business news source.
Keeping track of changes in labor laws can be a nightmare for small business owners and HR professionals. With us today to help us understand some of the new requirements that Maine businesses should be aware of in 2011 is Anne-Marie Storey, a partner at Rudman Winchell in Bangor. Anne-Marie specializes in employment and labor law. Welcome back.
Thank you very much.
We've had you on before. It's good to have you back, especially at this time of year. It's a new year, so it's a good time for business New Year's resolutions as well. And one of the resolutions should be to pay closer attention to some of these, especially the HR department, to some of these new laws that are out there, because they could pay off in the long run throughout the year. A couple things have been happening. We want to jump right in and have you walk us through some of the new things that the businesses and the HR folks need to pay attention to. First one we're going to talk about is the legislation pertaining to medical marijuana. That was signed by the governor back in April of 2010. Maine's now the 5th state to provide for dispensaries of medical-grade marijuana. The rules were promulgated in 2010. So what do employers need to know about that? I wasn't thinking about employers when I thought about the medical marijuana issue. How does it impact them?
It does impact employers, and basically what it says is that a person whose conduct is authorized under the statute, either as a user or an individual who assists a user, can't be discriminated against by their employer because of that status. What it's important for employers to know, though, is that it does not permit an employee to use marijuana at the workplace or to come to work under the influence of the marijuana.
So if I'm an employer with I've got drug policies and I have zero tolerance policies, those kind of things, how does this impact any of that? Do I have to rewrite everything?
Well, we're going to have to see how it plays out, because what we know is under this law you can't discriminate just because somebody is taking it for medical use. But it is clear that you don't have to allow them to work under the influence, and so what's going to happen when somebody needs to be a user at lunchtime or come to work when they're still under the influence is unclear, because of course under federal law it's still a criminal offense.
Yeah, that's the other thing I wanted to ask you about. So how does that, which one do we pay attention to, the federal law, the state law?
And again, that's going to have to play out because the state law isn't saying
it's illegal at the federal level.
It is.
Okay.
Yeah, and the state law does make a provision that says that you can't refuse to employ or otherwise penalize an employee for authorized actions under the Maine statute unless it's a violation of federal law as well. If it would put the employer in violation of federal law. And so there is an out for employers in that situation. But what we know is that they can't discriminate against somebody just because they are taking advantage of the medical marijuana law.
Yeah, that seems very fuzzy, which is appropriate for this topic. Okay. All right. I had to throw one of those in. Okay, let's go into the number 2. The next one is the EEOC's adoption of new rules interpreting the Federal Genetic Information Non-Discrimination Act, the GINA. Obviously, this is about protecting employees and prohibits the use of genetic information in employment-making decisions, but tell me what that really means and what do I need to be watching out for as an employer?
Well, it means that it's a federal law that means that employers cannot request or use genetic information as a reason not to hire somebody or to discriminate against them in any way. So, for instance, if I happen to find out that an applicant has family members with breast cancer, I couldn't use that as a reason not to hire them because of my fear that that person might develop it and it might increase my health insurance cost, for instance. Now, Maine has had a law that covers the same thing for quite some time, so this isn't going to be new to all employers. There are some different provisions in the federal law, though, that are changing, and employers need to be very aware of.
Well, what kinds of things do you need to? Because I know that issue of whether the information was collected inadvertently as a part of another health claim or a workers' comp claim, those kinds of things. What do we need to look out for with that? Okay,
so if an employer were to request, because there is some medical information employers are entitled to have, and you mentioned workers' comp, that's correct, and also family medical leave. And so if, as a result of asking for lawful information under those kinds of statutes, an employer gets information that refers to or raises the issue of some genetic information, that could be called an inadvertent disclosure and is not necessarily a violation of the statute. But recently, the EEOC issued its final rules, which become effective on January 10. And in those final rules, it added a provision that was not in the original act that makes it specific to an employer that they have to have a paragraph in each request for medical information for whatever reason that discourages the doctor or the medical facility from providing anything relating to genetic information.
So that's before the request is made.
At the time the request is made, that language now needs to be in the request. So employers who use the standard Department of Labor FMLA forms, for instance, now are probably need to go back and add a paragraph either to the form itself or to the letter going to the medical facility.
Does that affect all employers? Are there any size limits? Are employers under 50, under 25?
No, it affects all employers.
Okay, and it's at the state and federal then. So
well, that provision is included only in the federal regulations, but I would recommend that all employers do it just to be on the safe side.
Right, and is this something they'll need to? If I'm a small employer, do I need to work with an attorney to do that, or is it? Will I be able to put the language in myself? I mean,
I think it depends on how savvy that small employer is. The language is in the final rules, which is on the website, and so there are a lot of employers out there who are very versed in using the Department of Labor website and can find that themselves. If not, they should seek the assistance of somebody.
Okay, and the last thing on that one then is, you mentioned the Department of Labor website a couple times. We're talking about the Federal Department of Labor.
Yes.
Okay, so that's a good place to go to really get some of this information. And you should be able to do a lot of it yourself, you think?
At least get a beginning understanding, and hopefully to know when you're
getting in
over
trouble.
your head. Yeah.
Right, exactly. We just have a couple of minutes left, but I do want to get to the last one, and we'll spend more time on it later too, perhaps. Changing the federal FMLA definition of parent, the Family Medical Leave Act. Tell me about that. So now the definition has been changed at the federal level?
It has. Right before the change, it covered a parent or somebody standing in place of a parent with some restrictions on who that person could be.
Do I get to use the phrase?
You can use the phrase.
In loco parentis.
Excellent.
I like the way that sounds. I'm sorry, go ahead. So someone standing in for the parent, it's broader now.
It is. It used to be that they required both financial support and day-to-day care of the child in order for someone to be.
Okay. In loco parentis. Thank you.
And what the new law has done is changed it to say it can be either or.
Okay.
And so it's expanded it to potential grandparents and also people who aren't related at all, maybe domestic partners.
Yeah, I was going to say
as well.
same-sex partners, those kinds of things.
Same-sex partners could fall.
Okay.
Certainly.
And Maine already had some of that provision for domestic partners, right?
Maine already had a provision for coverage of domestic partners and domestic partners' children, so it's likely that that portion of it was probably already covered under Maine law.
So, and we talked about this a little bit earlier too. There's some of the questions with that one are, what is financial support? What constitutes financial support? And what constitute day-to-day relationships? So how will we know those things?
I think it's going to be on a case-by-case basis. There is no bright line right now. We'll just have to decide what seems reasonable.
Okay, good. And will those be in state courts or federal courts, or how will those clarifications be made as we go along?
Well, it could be decisions from federal courts. It could also be more follow-up from the Department of Labor again, who might help us clarify things.
Good. Okay. Once again, looking at the Department of Labor website, perhaps to keep abreast of those things. Okay. And your HR folks should really be on top of that anyhow, and really paying attention, hopefully.
Yes.
Okay.
Definitely.
Good. We're going to wrap this segment right there. I'm going to keep you around. We can talk a little bit more about in depth on some of these things, and we'll see where we go from there.
All
so
right.
Stay right there.
Thank you very much.
You can catch more of this discussion in an exclusive afterthought segment seen only on the web. Just go to mainebiz.biz and click on the Mainebiz Sunday link. Stay with us. We'll be right back to discuss what Maine business can expect in 2011 when it comes to healthcare reform. Stay tuned.
Mainebiz Sunday is brought to you by Bangor Savings Bank, where you can enjoy free ATMs worldwide.